There are some pieces of legislation that I can stand proudly in this House, hand on heart, and say this is what our people want. I'm thinking of legislation like the repealing of the 2004 Foreshore and Seabed Act, or the private members bill that just happened to be in my name. For example, the GST off healthy food one, and the one that's coming up, the removal of 1080 poison. But I'm sorry to say that this bill is not one of those bills. I would have to say that not one of the constituents that I've spoken to in Te Taitonga has written to me, rung me or knocked my door down, pleading that we do something about enhancing the powers of the court to bring about the collection of fines. To be quite frank, the issue of overdue fines is inevitably going to have a disproportionate impact on Māori because, as this House well knows, Māori are 4 to 5 times more likely to be apprehended, prosecuted and convicted for a criminal offence than Pākehā. One of the great realisations of the work proceeding under the Drivers of Crime strategy is the absolute complexity involved in addressing the overrepresentation of Māori. And it is vital that the court system is also under the same scrutiny that we should demand all levels of the criminal justice system be exposed to. But this is not the time to analyse the causes behind such a disproportionate overrepresentation of Māori in the criminal justice framework. Our focus instead must be on recognising that this inequality exists and recognising also that socio-economic circumstances also provide a particular backdrop for understanding the precise impact of this Courts and Criminal Matters Bill. With a median income of approximately $20,000 per annum, Māori will inevitably be adversely affected by court-imposed fines and the offender levy. There is already a virtual avalanche of evidence about the barriers that low-income whānau already experience about obtaining access to credit, to rental tenancies, to employment and to bridging finance to put towards home ownership or even a decent car that won't end up costing more than it's worth through unpaid fines. The possibility, therefore, that this bill will bring about a whole new tranche of pressures upon whānau is something that we have to take very seriously. Over the passage of time, Māori Party MPs have brought to this Parliament the devastating stories of families dealing with precarious financial difficulties, falling prey to ruthless lenders, getting away with obscene rates of interest. We would hate to think that one solution to address the millions outstanding in reparation and penalties forces our poorest communities to turn to unscrupulous moneylenders whose only concern is profit. Mr Speaker, I want to acknowledge here the responsible and wise counsel for the Minister for Courts, who has received these concerns both from the Māori Party, but also, I believe, from the Minister for Māori Affairs and his agency, Te Puni Kōkiri. She has made it very clear that the purpose of this bill is not about more penalties and punishments, but it is about creating incentives for those with overdue fines to contact the court. I think that there is a statement made by the Minister which has enormous meaning. It is that all impacts from these initiatives can be avoided by a person with overdue fines contacting the court to resolve them. Now, this sounds so easy, and we hope it will be. We welcome the initiative of establishing an 0800 telephone number to encourage people to pick up the phone and subsequently for the court to help them with options for getting the matter resolved. Now, I need to talk about this 0800 number because I remember that when I was in a community centre, law centre, people would not able to use the 0800 number because as soon as they dialed and they were on a toll bar, it would switch off. So I hope that in this case that has been taken care of and that is no longer the case, but they will still be able to call an 0800 line without having a toll bar put in place. This is a culture shift, being able to go to the court and discuss the fines, unpaid fines. It is a culture shift, and it will require a significant investment in PR to inform people of the helpline and to make the message clear that if they do contact the court to resolve their fines, they will thus cease to be put through the credit reporting queue. Why I say a culture shift is because it will require considerable effort on behalf of the courts to convince the public that they are not on the chase to slap an even greater fine on a lapsed offender, or worse yet, to pack them off to jail. I want to make it known that the Māori Party is the first to promote the value of collective responsibility, and we understand the concept of paying for one's dues. If money is owing and fines are due, it is a responsibility that must be met. But we also understand the dire situations of just too many families, and we want to ensure that they are fully informed of the chain of events that may be triggered if they do not take action. The key is in getting the message through that if a family is facing financial hardship, that there are options available to help them resolve their debt. And these options do not involve loan sharks in any shape or form. The options are all about taking the responsibility to talk to the courts about ways to resolve debt, while at the same time taking into account financial circumstances. It might be about setting up a time payment option, or there might be the possibility of having the fines remitted and an alternative sentence imposed. Of course, ideally, we would want to take a preventative approach to ensuring the crime doesn't happen in the first place. And I want to give praise where praise is due for a story relayed to me about police in Kaitaia who have been helping young people to stay safe and on the right side of the law by programs which help them to get their driver's licence. I believe there's even programs in practical car maintenance. Such basic strategies are a really excellent investment which we would hope would avoid further criminalisation. We are concerned about the exchange of information that this bill will authorise in the amendment to the Summary Proceedings Act. The amendments will authorise the release of the amount of overdue penalties by the Ministry of Justice to credit reporting agencies to assist with fines enforcement. There will also be provisions to give the courts priority over secured creditors, to seize property where the overdue penalties were overdue before the property was purchased. We understand from the Minister that there will be a review of these provisions in 2 years' time, but we are not convinced that there are sufficient measures in place to prevent the capacity for abuse by authorities. We will be looking forward to hearing from the Privacy Commissioner during the Select Committee stage as to the precise extent of the invasive powers. Another part of this bill is the intervention to approach an employer or work and income when the fine is overdue rather than the person itself, and we wonder at the balance between privacy concerns and the public good. Mr Speaker, we do really worry that this bill could place whānau in the situation of turning to marginal lending agencies, and so another expectation the party would like the Select Committee to turn its attention to is the detail around the communication strategy to ensure the information is out there to encourage people to proactively contact the court. Mr Speaker, we balance the onus of collective responsibility with other values such as rangatiratanga and manaakitanga. We are acutely aware that we would not want to disadvantage victims further, and so we support the notion of creating strategies to encourage the payment of debts or compensation owing. We are prepared to let this bill go through to the Select Committee stage, but we will certainly be keen to hear all of the arguments, all of the evidence that comes from those who have the most potential to be affected by this legislation. Thank you.